Hi, my name is Carrie Rinker of Rinker Law. Today I'm going to be presenting on a survey of legal issues affecting livestock producers. For those of you that don't know me, I grew up on a beef cattle farm in central Illinois. I grew up baling hay and showing cattle through 4-H and FFA. I did my undergrad in animal science, and I even have a master's degree in beef cattle nutrition. I'm currently the chairperson of the American Bar Association General Practice Solo and Small Farm Division's Agriculture Law Committee, which is a bit of a mouthful. For those of you listening to the program, would love for you to get involved if you're at all interested. And my client base ranges from livestock producers to food entrepreneurs to small to mid-sized agribusinesses. My office is located here in New York City, in Midtown East. And for those of you watching the podcast live or the video recording, if you're here in New York, I would love to meet you. I am going to be skipping through a lot of different livestock law issues today, so please hold on tight as I'll be giving a cursory overview of a lot of different topics, beginning with livestock animal cruelty law, then going into bull and horse leases, following up with embryo transfer contracts, a right to farm law, and then on the second half of the program, I'm going to be going into the National Organic Program, direct farm marketing with meat production, on-farm poultry slaughter, and then closing the program, if we have time, with touching on concentrated animal feeding operations, or CAFOs. So let's start off with livestock animal cruelty law. Because this is a national program, I just wanted to start with a big picture on what's going on from a national perspective with livestock animal cruelty law. If you take all the different states' laws in this area, they break down into 5 basic approaches. One is ordinary rights, the second is animal rescue, the third is limited law enforcement, the fourth is law enforcement, and the fifth is community policing. And to be clear, when I'm talking about these state approaches, I'm really talking about the roles that humane societies, animal humane societies, play within those states. So let's go ahead and go through each of those 5 approaches. And let's begin with the ordinary rights approach. This is by far the most common. In fact, about 24 states have this approach. And within these states, humane societies operate animal shelters and educate the community about animal abuse. However, in these states, humane societies don't have police power, as we will see in other states. Jurisdictions with this approach may still regulate humane societies in other functions, such as the types of chemicals used in euthanasia. So here are some of the states with this approach, and I have a few states highlighted. Illinois is highlighted because I'm from Illinois. Texas, I did my undergrad at Texas A&M, and I worked briefly in Cheyenne, Wyoming. But for those of you that are watching the program, perhaps you live in some of these jurisdictions. Now, within this broad ordinary rights approach, you can break it down even further into states that govern this area of law with a government entity. For example, Colorado has a Colorado Bureau of Animal Protection. There are some states that have an appointment of specific individuals that monitor this. North Carolina and North Dakota have a process which agents are appointed regardless of whether or not they're from a humane society or not. Illinois, though, requires the Humane Society to endorse an appointment, but the agent does not have a membership to the Humane Society. On the other hand, some states have full-time animal cruelty officers who are government employees. An example of this is Texas. Let's go on to the second major approach, and that is the animal rescue approach. In these states, humane society representatives serve a role at the crime scene by seizing the alleged abused animals and provide them treatment. In these states, the humane societies do have limited police power. They may also investigate alleged animal cruelty, but they are unable to obtain search warrants. Here are a few states that offer this approach. Alabama, Florida, I have it highlighted because New York has a long winter and I dream of Florida oftentimes. All right, the third approach, the limited law enforcement approach, okay? In these states, humane societies are allowed to investigate alleged animal cruelty, seize the animals, and then conduct the searches. But the police powers in the state are still somewhat limited. They can't use any firearms, and they cannot arrest without permission. For instance, Kentucky gives Humane Society agents all the powers of peace officers except for arrest to enforce animal cruelty provisions. The Humane Society agent has to request an actual peace officer to arrest the offender. Let's move. The states with this approach include Kentucky, Nevada, South Carolina, Tennessee, Vermont, Virginia, and Washington. The fourth major approach is the law enforcement approach, and we'll quickly learn that this is New York. Humane societies here are granted all police powers, including the ability to seize animals, investigate animal abuse, execute search warrants, issue citations, and also arrest offenders. Also in these states, they usually have the right to carry a firearm. For instance, Pennsylvania denotes a whole chapter of their code to Humane Society agents with regulations ranging from appointment, qualifications, training, and powers. To be more specific, these states usually have a detailed regulatory system to monitor and train these agents because their powers are so broad. California's regime is complex enough to designate 2 levels of Humane Society agents, which New York does not have. So different states with this approach include New Jersey, which is next door, New York, Hawaii, California, as was mentioned, Pennsylvania, and Rhode Island. The fifth major approach is the community policing approach. And in these states, or this one state, they designate an active police officer actually to serve as the humane officer who will work with the Humane Society side by side. The humane officer retains all police powers but investigates animal cruelty violations and then enforces the animal cruelty law in the state. And the one state to my knowledge that's using this approach is the great state of Indiana. Very briefly, because we are in New York, I do want to note about animal cruelty law here in New York. I'm going to be giving an entire presentation on New York livestock animal cruelty law via Lawline on November 12th. So I encourage those of you who are in New York or thinking about practicing in New York to participate in that webinar. But this is our animal cruelty statute. It's under the New York Agriculture and Markets Law. And you'll usually find the animal cruelty laws, whether they're dealing with livestock law or companion animals, within the agriculture law statute or code in that state, although it could be in other sections of the code. But here in New York, under Section 350, subsection 2, torture or cruelty, including an action or an omission to act or neglect, where unjustifiable physical pain, suffering, or death is caused, is prescribed. Then we have both in New York a misdemeanor animal cruelty statute and a felony animal cruelty statute. The felony applies to companion animals, okay? But because we're talking about livestock here today, we're going to be honing in on the misdemeanor section, which prescribes the overdriving, overloading, unjustifiable maiming, mutilation, or killing of any animal, or the deprivation of 4 things: food, drink, and sustenance. We have a court case in New York, People v. Mahogany, that defines sustenance as both veterinary care and shelter. So we're really talking about 4 things, and that's food, drink, veterinary care, and shelter in New York. And I would like the participants here today to observe that in New York, the key word is necessary. It's not reasonable. It's not 24 hours a day food and water access. And so pay attention to the language within your state statutes with livestock animal cruelty law. As I mentioned before, here in New York, peace officers, duly incorporated societies for the prevention of cruelty of animals, can actually seize farm animals. They can get a warrant, they can go to court if they believe, if they have reasonable belief that animals have gone 12 successive hours without ample or necessary, keyword necessary, food, drink, or sustenance. All right, and as I just mentioned, under Section 372 of our statute here in New York, these peace officers can actually obtain warrants. And the law in this area varies from state to state, and I really encourage everybody participating. If you're going to practice in livestock law, get to know the livestock animal cruelty law in your state. All right, let's go ahead and move on to bull leases. And as a disclosure, I realize that I am a cattle girl, so I'm mostly interested in bull leases, but I realize that clients are going to come to you and want ram leases or boar leases, depending on the species of livestock that you're dealing with. But just as an example today, I'm going to work through bull leases. So typically in a transaction here, that you're going to have a bull owner that's going to be allowing another cattle owner to lease their bull during the breeding season, okay? And then the bull lease should actually define how long that breeding season is. Is it 3 months? Is it 9 months? Is it 2 months? What is the breeding season and how long is that bull going to be leased? And I know this seems like common sense, but how many bulls will be leased? Is it just 1? Are there 5? What are the payment terms? And then 4th, this is a biggie. What are the representations that the bull owner is going to be making to the other lessee, okay? So things that might be typical representations: the health of the bull. Did he recently go to the veterinarian and get a health check? The body condition score of the bull. Fertility, okay? The bull owner is going to promise that his bull is fertile to breed their cows. Makes sense. Depending on the type of operation, I came from a Simmental cattle farm. So if my father was leasing a bull, he would want to make sure that they were a registered Simmental bull. So breed registration might come up. 5th, they might be interested in a guarantee as to the pedigree. The caveat with that is the bull owner might only be able to represent what he has control over or knowledge of. There might be a problem with that bull's sire or grandsire or maternal granddam that might later come up later. So to their knowledge, you're going to make a representation as to the pedigree and the genetics of that particular animal. Structural soundness, libido or sex drive might be a representation. I actually judge cattle shows in the summer, and so when I'm here in New York, one of my jokes that I tell people is how you judge bulls. You judge them by butts, nuts, and guts. And then the next question is why nuts? And I tell them that the size of testicles is actually scientifically correlated with sex drive. And this is important. If you're leasing a bull, you want the bull to want to breed the cows. So that is certainly a representation that needs to be made in the bull lease. Perhaps genetic DNA markers. This is part of my thesis research, was dealing with genetic DNA markers. So maybe there were some tests that were performed that bull owner is going to make a representation of. Expected progeny differences, whereas talked about as the industry as EPDs, or also the disposition or how calm the animal is, especially if, particularly if it's in a cow herd where that might be an issue. That could be a representation that's made. On the flip side of things, the cow herd that the bull is going to be going to might also want to be making some representations that their cow herd is healthy, that their cows are fertile. And this is really only an issue if there's a penalty for the bull owner if the bull has low conception rates. But if that's the case, then you definitely want the lessee to represent that their cows are fertile. And then the number of cows that the bulls will breed. Delivery might be an issue in a bull lease. Is the bull owner taking the bull to the cow herd, or is there going to be a pickup? Who is bearing the risk of death, injury, or illness of the bull? And the lease should also talk about the liability for injuries to people from the bull. And in my opinion, the lessee should have the risk here, which makes sense if the bull is on their property. However, that could be an issue that the lessee wants the bull owner to bear that risk of liability. With that being said, talking about liability, sometimes insurance comes up on these bull leases, but I have found that to be rare. Sometimes, as I mentioned, there are performance requirements with the bull lease. Maybe there's a minimum breeding rate or a guarantee that is made. If you represent the bull owner, make sure there are provisions relating to drought, weather extremes, or deficient grazing conditions if there is such a minimum breeding rate, as that can affect the bull's ability to breed. And the bull lease could also include some good management practices, or more colloquially referred to as GMPs, good management practices. And that could include information on herd health, veterinary care, feeding regime, including dietary supplements. The bull owner might want the right of inspection to the cow herd at any time that he or she wants. And the lessee might even want the option to purchase the bull at the end of the lease. So if that's the case, the lease itself needs to, how long is that option period going to be and what are the terms? As a few cleanup matters, who's going to own the progeny? Now, oftentimes it's the lessee, and if you look on the slide, it says should be owned by the tenant. That's a typo. It should say should be owned by the lessee. Now, as a caveat, I've had clients come to me and say, well, it's a bull lease, but we're going to co-own the progeny. And then my response to them is, that's not a bull lease. This is a general partnership agreement, and that's what we should be drafting, because when two people go into business to share profits, that's a general partnership. And if the progeny is then going to be co-owned, then that's really what's taking place and not a true bull lease situation. So if it is a true bull lease, then it should specifically state that this is not a partnership and there is no joint venture relationship. And as a final issue, I recommend that there be a confidentiality clause in the agreement. For those of you that are participating that do horse leases, I'm just going to briefly mention that these leases really vary. Are we talking about mares, geldings, stallions? A few issues here that bullet points that I mentioned here are shoeing, farrier fees, training expenses, the right to sublease, health, veterinary care, and insurance. Insurance is a huge issue in the equine industry. As I mentioned, I am the chairperson of the American Bar Association General Practice Solo and Small Firm Division's Agricultural Law Committee, and I've moderated a lot of different webinars with that. There's a great program with the ABA on some equine contract issues, and Julie Frischman there in Michigan talks about equine insurance, and she also participated in a crop and livestock insurance program that I moderated and went into significant detail on equine insurance. So if you're wanting more information on mortality insurance, major medical for the equine industry, or the loss of use insurance, I recommend those webinars. For those of you that are interested in embryo transfer contracts, I'm going to be giving an entire Lawline presentation on this topic soon. So here today, for purposes of time, I'm just going to be skimming the surface. In the upcoming presentation, I'm going to be talking a little bit more about the animal science background with embryo transfer contracts. So I encourage you to also participate in that webinar. So there are three major types of embryo transfer contracts. We're really only going to be talking about the first one here today, and that's the recipient agreement. But I've also drafted a breeder agreement and a flesh agreement. Now the client might not come to you and say, I would like to have a flesh agreement or a breeder agreement. They're usually just going to ask for an ET contract, an embryo transfer contract. So please keep that in mind. Now, when do you use a recipient agreement? This is when a cattle producer is selling a bred embryo transfer recipient cow and or an embryo transfer calf to another cattle producer. And I took this photograph during my master's program there at the University of Illinois. So let's go through an example transaction. I think that that's the best way to explain embryo transfer contracts, okay? So Farmer Rinker, let's say he's my father, right? He enters into a contract with Farmer Smith. So in this scenario, Farmer Smith is either one of two things. He's either a non-certified embryologist, and he therefore takes the recipient to an embryologist itself, like Transova as an example, or Farmer Smith is a certified embryologist himself or herself. And that's rare. It's really rare for that to happen, but it can. An example of a university that certifies embryologists is Colorado State University. So the embryologist needs embryos to transfer into the recipient cow. And I just wanted to note that my family does embryo transfer work. And this is a topic that I actually get a lot of phone calls and inquiries about. So for those of you that are interested in practicing in the livestock arena, I think that this is something that you should familiarize yourself to. This transaction that I'm giving an example to is more with beef cattle, okay? So it's going to be different depending on if it's dairy cattle, beef cattle, or a different species, okay? So, but I'm gonna work through a cattle example. So the embryologist needs embryos to transfer into the recipient cow. The frozen embryos can be shipped from a cattle operation of choice, or fresh embryos, or the donor female is at the embryologist site where she was recently fleshed himself. Then either the fresh embryos or the frozen embryos are transferred into the recipient cow, or the recip, if you want to speak your client's language. It's the recip cow. All right, so the recipient owner must now confirm the pregnancy. He or she takes the recipient cow home and waits 2 to 3 weeks to see if she is bred. So in humans, it'd be 28 days. In cows, it's about 21 days to see if she's bred, to go through the estrus cycle. And then this is an example of a cow being in standing heat, for those non-animal science majors listening in. All right, so the recipient owner must then confirm the pregnancy, and the recipient owner performs a pregnancy check at 45 days. If pregnant, then Farmer Smith then notifies Farmer Rinker and says, hey, we got a pregnant cow. But they might not be pregnant yet, or we just wanted to confirm again at 60 days. So Farmer Smith performs another pregnancy check at 60 days. Ultrasound might be necessary to determine the sex if the ET contract requires that. At that point, at 60 days, if they're confirmed pregnant at 45 and then again at 60, or just even at 60, then the pregnancy is then confirmed. Usually under the terms of the contract, it will as well. Farmer Smith typically pays for labor and costs associated with this pregnancy check process. However, Farmer Smith could charge Farmer Rinker, about $5 to $10 per cow for just various labor expenses with this. During this holding pattern, Farmer Rinker does not typically owe money during this time. Payment is not due until pregnancy is confirmed around 60 days. Then Farmer Rinker will pay Farmer Smith X number of dollars per cow that is confirmed pregnant. Not every recip cow will be pregnant. In this hypothetical, let's say Farmer Smith informs Farmer Rinker that he has 5 confirmed cows, pregnant cows. All right, so one of two things is going to happen then, according to the contract. Farmer Rinker will pick up 5 pregnant recip cows within 70 days, let's say, and pay the X number of dollars for the cow who is confirmed pregnant. Just as a ballpark, for those of you that don't know, it could be between $1,800 and $2,200 there per pregnant cow. If Farmer Rinker doesn't pick up the cow-calf on time, then late fees, penalties under the terms of the contract might apply then. So I would suggest having a late fee depending on who you're representing in the terms of the contract. Option 2, Farmer Smith will care for the pregnant recip cow through weaning, all right? And weaning with beef cattle is typically between 4 to 6 months. In my master's program at the University of Illinois, we would wean cattle at 2 months, So the time of weaning should actually be memorialized there in the ET contract, especially if that's the case. And then Farmer Rinker will typically only get the embryo transfer calf and will pay upon the receipt of that calf. Let's say it's between $1,100 and $1,500. All right, Farmer Rinker, let's say Farmer Rinker then takes the ET calf home to the Rinker Ranch, which is located in Shelbyville, Illinois. If Farmer Rinker uses an embryo that he does not own, that is, he purchased it from another producer with the use of a flush agreement, which we're not talking about here today, then most cattle breed associations will require some type of verification of the parentage of both the dam, which is the mother, and the sire, which is the father, before the registration will be allowed. So an example that would be done would be a genetic DNA test with the use of a hair sample. Farmer Rinker is the person applying for the registration. He's the owner. He wants to get it registered, not Farmer Smith. Just wanted to bring that out. So in this example transaction, if Farmer Rinker does not pay his fee to Farmer Smith, then the embryo transfer contract may ask Farmer Rinker to assign the ET calf's registration paper to Farmer Smith as security. And I see this a lot in these ET contracts as well. So what's currently done in the industry, the recipient owner will sometimes have an agreement drafted to give to the breeder, and oftentimes what I'm seeing is that these recipient agreements are just drafted without lawyers, or they are drafted with lawyers and they're really detailed, and they work in favor of the recipient owner quite dramatically. But oftentimes it's not drafted by an attorney. And the breeder is rarely given a chance to negotiate the terms of this recipient agreement, which I think is a little bit of a cultural problem within the livestock industry. A livestock owner is handed a contract, they aren't retaining an attorney, they don't realize that the terms of that contract are negotiable. So it's just something to really talk about with your clients, that just because somebody hands you a contract doesn't mean that you have to sign it as is. So a few other things to consider with the recipient agreement is the purchase or lease price of the recipient cow, the management of the ET calf, payment terms, instructions for the receipt or the shipment of the frozen embryos, the embryo transfer fees for open cows, dates, procedures, and costs associated with pregnancy check and palpation or ultrasound charges. And here are a few other provisions with embryo transfer, such as fees for open cows, dates, procedures, and costs associated with pregnancy checks, etc. And for purposes of time, I'm going to go ahead and skip through this section, but I would really encourage those of you that are on this webinar to listen into the entire CLE that I'm doing on ET contracts. I'm going to be talking more specifics on recipient agreements, breeder agreements, and even flush agreements. Let's go ahead and move into the right to farm law. Okay, so all 50 states actually have a right to farm law, and this can really vary from state to state. The National Agricultural Law Center has a great library on their website, and they actually have a nice compilation of all the different states' right to farm laws. So for those of you that are interested in learning more about your state or what other states are doing, I really recommend visiting that website. Today, I'm really going to only be talking about what we do here in New York, and I realize that's only going to apply to those of you that are also here in New York, but just as an example. As a broad picture, the broad stroke is that right to farm laws protect farmers and ranchers from nuisance lawsuits from people that move into a rural area and then file a lawsuit, like a nuisance or a tort suit, in attempt to cease that livestock operation. So what are we doing here in New York? So in New York, we have agriculture districts, and it's provided under the New York State Constitution, actually, in the provision there. And the purpose is to encourage the development and improvement of agricultural lands within the state of New York. And then we also then have a statute that talks more about the agriculture districts. And within this statute, it essentially states that local governments cannot unreasonably restrict or regulate farm operations within these agriculture districts. Here in New York, you can actually go to a map and you can see the different lands that are within agriculture districts. And so this is different than a zoning regulation, okay? So this is a broader stroke than that here in New York. Notably, the definition of a farm operation here in New York includes farms that produce crops, livestock, which we're concentrating here today, and livestock products. It even includes timber processing. So it's a very broad definition here in New York on what is considered a farm operation. And there, from an academic perspective, there's a lot of talk with different states. Should aquaculture be included in the definition of farm operation or not? So you will see differences from state to state on how they define a farm operation, or whatever the statutory term is there. So under Section 308, under the New York State Department of Agriculture statute here, under Section 308, the Department of Agriculture issues opinions upon request on what is considered a sound agricultural practice. So the Department of Agriculture in New York may consider the operation of farm equipment, the proper use of agriculture chemicals, the direct sale of consumers on on-farm products, agritourism, and other practices. And it says here that the Department of Agriculture may consult with the U.S. Department of Agriculture or Cornell. Cornell is the land grant university here in New York, so that's going to change from state to state. Like in Texas, it's going to be Texas A&M University Extension. In Illinois, it's going to be the University of Illinois Extension. In New Jersey, it's going to be Rutgers. But look at the right to farm law in your state. So if a farmer is doing a sound agricultural practice within an agricultural district, then somebody cannot come in New York and sue them for nuisance. So that's the relevance here with why are we determining whether or not a farmer is using a sound agricultural practice or not. Okay, so, and I just wanted to note that we're really only talking about a nuisance nuisance. We're talking about noise, we're talking about smells, we're talking about nuisance suits. We're not talking about, other types of things that a farmer might do. And there's a lot of confusion in this, actually. I remember I had a farmer a year ago come to me with a completely unrelated problem. And she goes, "But Carrie, there's a right to farm. We have a right to farm." And it was a completely different issue. So from a practical standpoint, the right to farm is really a bar to a private nuisance suit. Additionally, with that, in New York, the New York Department of Agriculture and Markets can determine whether a local law is unreasonably restrictive on that farm operation. Okay, so the New York Department of Agriculture will look at whether or not it adversely affects the farm operator's ability to manage the farm operation effectively and efficiently. Whether or not it restricts the production options, which could affect the economic viability of the farm or cause a lengthy delay in the construction of a farm building or implementation of a practice, cost of compliance, or the farm operation. So in other words, there could be a locality or a zoning board that may be viewed as having a zoning ordinance that's restrictive on a farm, and that could include an urban farm as well. Okay, and we're really only looking at that urban or suburban farm, probably more of the suburban farm that's within an agricultural district. So I'm here in New York. We've got rooftop farms in Greenpoint, Brooklyn. There's no agricultural district in Greenpoint, Brooklyn. Okay, but if you go into some of these counties right north of the city, there are going to be some suburban farms that are in agriculture districts. And that locality may have a zoning ordinance that's restrictive on that farm. And if that farm believes that it is unreasonably restrictive, then in New York, they can get a decision from the New York Department of Agriculture. Now, the law is going to definitely change from state to state. I'm just showing you this as an example of what we do here in New York in this area. So the purpose of all this is to encourage localities to also provide a right to farm law exemption in its land use code there at the local level. I also wanted to note in New York, we have a New York State Agriculture Mediation Program. I am on the roster for that program. It's funded through the U.S. Department of Agriculture, and we actually mediate these right to farm disputes. And I think around 35 different states around the country have this mediation program. I know, in fact, Texas does. There's a lot of different states that have this program that mediate these right to farm disputes, and also federal farm program disputes. If a client comes to you with this type of issue, I would definitely recommend that they participate in that mediation program with the adjacent landowner that's threatening the private nuisance suit. Let's move on to the National Organic Program. And this stuff, I have to admit, is complex. I could spend an entire hour lecturing on the National Organic Program, and I'm just going to be scratching the surface today. But I think that it's important to at least scratch the surface so that everyone here participating can at least see the big broad strokes within NOP, the National Organic Program. I have had livestock producers come to my office and say, well, we're producing organic beef. It's going to be organic milk, organic cheese. And I hope that they know that that is a very specific program that they have to go through in order to use the word organic. And they can't just use it because they feel like they're producing all natural or grass-fed beef. Okay, so let's talk about the National Organic Program. Congress, it's a federal statute, enacted the Organic Foods Production Act in 1990. Okay, so we now have these national standards regulating this area of law, and the statute said the U.S. Department of Agriculture, you need to establish these national standards for organic production and handling. On in December of 2000, the USDA published a final rule that created the organic standards. And if you think about it, that's, not even 15 years ago. So this is a pretty new area of law. And I think only in the last few years, I have felt like there has been education in the industry, both with agricultural lawyers and producers. There's a lot of excitement and a lot of people that are interested in learning about the different standards regulating the word organic. Specifically, within the U.S. Department of Agriculture umbrella, the Agriculture Marketing Service, or AMS, regulates NOP, the National Organic Program. So lots of little acronyms. So as of October in 2002, for a producer or handler to sell, label, or represent that an agricultural product is organic, then it must comply with these standards that have been promulgated. So because we're talking about livestock issues today, I thought it was only appropriate that we talk about what is livestock according to the National Organic Program. And I wanted to note that it does not include aquatic animals. It excludes aquaculture. So I just wanted to note that. But it does include domesticated game. Okay, so I've got, if somebody is raising deer, that's going to be considered livestock under the statute. There are a few exceptions under the statute, and I'm going to touch upon them very briefly. Number one, if the production or handling operation has a gross income from sales totaling $5,000 or less. Okay, so if we're talking about beef cattle, we're maybe only talking about 2 steers, right? They go to market or something like that. So it doesn't take very much in agriculture for things to add up to $5,000. You're mostly going to see this on the produce side of things, but it is an important exception for those of you that have clients that might have a hobby farm on the side. So in order to fit this exception, it primarily applies to direct-to-consumer farmers, right? So a livestock producer has his steer that he sells. Maybe he has a small CSA for a couple people that buy a share of that. And then if he or she wanted to say that it's organic, then it would be an exception here under the statute. With that being said, that person still must comply with the applicable organic production and handling requirements without going through the National Organic Program certification program. Okay, so in theory, they have the same regulations, but they just don't have to go through the federal certification program. And there's also record keeping requirements that apply to that as well, and we'll talk more about that here in a few minutes. A second exception is with the handling operation that handles agriculture products containing less than 70% organic ingredients by total weight. Whew, that's a mouthful. So what is a handling operation? Let's think about that potentially being a restaurant, okay? And this is also very, very specific with the 70%, but I just wanted to note that that is also an exception. And the third exception that we're going to be talking about here very briefly today is a handling operation that identifies ingredients as organic on the information panel only. And for those of you that are looking online with the screen, I have a dog cookie ingredient list, and you can see the word organic listed for some of the ingredients that are listed there. Organic brown rice flour, organic millet flour, organic honey, etc. So if you think of like a Snickers bar, okay, so the Snickers bar could say organic peanuts, whereas the other ingredients within the bar might not be organic. And there are two main exclusions from the National Organic Program certification program, one being handling operations that sell only organic products that are packaged or otherwise enclosed in a container before the operation receives it or acquires the product and it remains in the same package. Or the second is a retail food establishment, and that would be like a restaurant that that processes on the premises raw and ready to eat food from products that were previously labeled as organic. So that would allow that restaurant to be able to advertise that it has organic, entrees, right? Okay. So as I mentioned before with record keeping requirements, because we're only scratching the surface today, I'm not going to be going into in depth about it, but it matters on whether or not we're talking about a certified operation, an exempted operation. So that farmer who's selling a couple steers less than $5,000, that's an exempted operation, or an excluded operation. Okay, so the record keeping is going to vary, and you should figure out which classification that your client belongs to before you opine on whether or not they're adhering to the record keeping requirements under the statute. So there are various allowed and prohibited substances, methods, and ingredients under the statute for a certified operation to sell, label, or represent a product as organic. It must produce or handle the product without the use of synthetic substances and ingredients unless it is on the approved list, the national list, all right? So in that list, so is very long. And I would encourage those of you that are interested in practicing this area to take a look at it to understand how long that it really is. This picture here on the screen is a picture of my brother showing at Louisville. I love going there and seeing that green sawdust. It's really pretty. So certified operations must also produce and handle products without the use of prohibited non-synthetic or non-agricultural substances unless they're on this national approved list. Notably, there are certain vaccines, for example, that could be used for limited purposes that are on this national list, all right? And perhaps those vaccines are just used for a limited time while the animal is sick. You can't use an excluded method. All right, so what are some of these excluded methods? One of them is the use of genetically modified organisms, or GMOs. So those are prohibited. I get a lot of questions sometimes about, well, Carrie, why don't we have a label for non-GMOs? Like, why don't we have a label about this? My response is, well, we kind of already do have a label for that, and that is the organic label, okay? So if something is labeled organic, as a consumer, you know that it's GMO free. So if that is an issue that's important to you, we do already have a label somewhat on regulating that area. So GMOs, an excluded method. And then also other methods that influence the growth and development by means that are not possible under natural conditions. What do I mean by that? Cell fusion, DNA technology, gene deletion, etc. Now, because we're talking about livestock today, I wanted to make perfectly clear that this does not include traditional breeding issues or even in vitro fertilization. And that's whenever you're actually doing the fertilization of the egg and the sperm outside of the body. That is not an excluded method. Or traditional breeding, when my father goes through a bull catalog and picks out some great bull semen to artificially inseminate our cows, that is not an excluded method. That is just a traditional breeding technique, okay? Also with livestock production, livestock products intended to be sold, labeled, or represented as organic must be produced from livestock raised in organic management conditions from the last third of gestation or hatching. There are 3 exceptions to this, one of which, poultry. This is from the 2nd day of life forward. With milk, we're talking about dairy animals with 1 year of organic handling. And with breeding livestock, we're talking about at the time of the birth. With livestock feed, something to keep in mind, must be given a feed ration that is composed of organic agricultural products, and that includes grains, hay, silage, pasture, etc. Note that organic does not necessarily mean grass-fed. Consumers don't know that, right? Because consumers think grass-fed equals organic. I just wanted to be really clear that there could be a cattle feed yard, which we'll learn here in a second is a concentrated animal feeding operation, okay? And they are fed corn, organic corn, okay? And they aren't fed any grass, and they could still be organic. I just wanted to be very crystal clear that the two of those terms are not mutually exclusive. Another word on livestock health and well-being. Under the statute, there are requirements to maintain livestock health care within, the flock or the herd, whatever type of livestock operation. And then there are regulations dealing with vaccines and the use of veterinary medicines when necessary. The livestock producers who are wanting to be part of this program must allow their livestock exercise, freedom of movement, and the reduction of stress. So going back to that example that I was just mentioning about the cattle feed yard who could be a CAFO. Now, and as we'll learn here in a second, CAFO has nothing to do with the size of the space. It has more to do with the number of animals. But if you are working with a client who is a CAFO, who wants to be part of the National Organic Program, please note that there is a requirement that they allow for this exercise, freedom of movement, etc. And there are some variances that are allowed, especially for the acts of God, if there is a natural disaster, drought, wind, flood, etc. So I definitely recommend taking a look at the statute there on variances. And very briefly, I just wanted to note that with labeling, and this stuff can get very specific, but there are different kinds of labels that mean different types of things. Number one, 100% organic, that's the strongest. Number two, organic. And then number three, made with organic. So thinking about that Snickers bar, right? Made with organic peanuts. Or fourth, products with less than 70% organically produced ingredients. And this percentage is determined by weight in solid form. And I would recommend reviewing the statute for more specifics on those requirements. We have a few more minutes, so I'm going to go ahead and skip to direct marketing of meat products, and if we have time, get into CAFOs. Very briefly, I wanted to give an overview of the Federal Meat Inspection Act. And the statute divides animals in two different major categories. One is amenable livestock. This means answerable livestock, answerable to the Federal Meat Inspection Act. And that includes cattle, sheep, goats, so your red meat animals for the most part there. And then there's also amenable poultry, chickens, turkey, ducks, geese, guineas, etc. So what is non-amenable or non-answerable? That's going to be game animals, the deer, right? And other birds. Even if a farmer raises a domesticated species, it's still considered non-amenable. So think about that farmer who might be raising deer, right? So that is still going to be considered non-amenable under the Federal Meat Inspection Act. The Federal Act requires imported meat products to have inspection requirements equivalent to the U.S. requirements, must remain in the original packaging, and there should be a foreign establishment number listed there on the label. Very briefly, I wanted to talk about custom exempt slaughterhouses. This is a picture of me showing cattle in 1999. Wow. And So when I was showing cattle in 4-H, my family would oftentimes take our animals and use the meat from our 4-H projects as beef throughout the year. So this is exactly what we're talking about with this custom exempt slaughterhouses. It's when the owner themselves uses the meat that they are raising, okay? And sometimes it could not be the same person who owned it during their life. So for example, I could actually sell my 4-H steer to my neighbor, Farmer Jane. She now owns Farmer Jane, and she decides that she wants to butcher my steer for use for her own family. That would still be under the custom exempt slaughterhouse exemption. The meat here must be stamped not for sale. I have had clients come to me and say, but Carrie, everybody does this. They just do the custom exempt thing. They stamp it not for sale. They might sell it to some of the neighbor. No, that is illegal, okay? So make sure to pay attention to those regulations when you're talking about talking to a client who does direct marketing techniques with meat. So what's important here, and I don't think I was very clear about it, that these custom exempt plants are inspected periodically, but they don't have the same federal inspection and oversight as other slaughterhouses. Now, what happens to these non-amenable animals or these non-amenable slaughtering facilities? There are specialized state facilities that conduct butchering and processing for these non-amenable animals. So in New York, just to use New York as an example, there's something called an Article 5A license. This is under the New York Agriculture Markets Law. And there's a higher standard than that custom exempt plant, but it's still not to the level as a federally inspected plant. So I would look at whatever the law is on your state, but pay attention to these two different categories on amenable and non-amenable. Is your client selling their meat product direct to the consumer? So if you're in New York, all red meat from an amenable species must be slaughtered at a USDA inspected facility, okay? And some states allow for state inspected slaughterhouses if sold intrastate within the state, right? We don't have a lot of time left, so I'm just gonna scratch the surface here on farm poultry slaughter regulations, and then touch the surface too on CAFOs, and then wrap up. But basically, the big picture here is that under the federal statute, which is the Poultry Product Inspection Act, there is a big exception, and it's called the 1,000 bird limit exception. And so 1,000 birds is calculated in different ways. It could be 1,000 chickens, or if you're working with a turkey farmer, it could be 250 turkeys. So one turkey equals 4 chickens. And so what's the exception here? The exception, if they fit the criteria, which is going to include not only the number criteria, but that they own their own chickens or turkeys, that they're slaughtering the animals and using these sanitary standards, etc., that they don't have to be harvested at a federal inspected plant. So that's the importance there. And so I just wanted to note that please pay attention to the statute, whatever it is in the state. In New York, the poultry that is being harvested on-farm poultry slaughter under this 1,000 bird limit exception must be sold intrastate. It must be sold in New York. You can't go to New Jersey and go sell it. If you do that, you're crossing state lines, you're entering interstate commerce, and this exception no longer applies. Let's go ahead and skip to CAFOs, and just to be very, very brief, CAFOs is a numbers game, and this is not confined animal feeding operations. It is concentrated animal feeding operations, and it's not a factory farm. These are different terms. The legal term is a concentrated animal feeding operations. In New York, New York divides things by CAFOs and AFOs, okay, that's an animal feeding operation. And it's a pure numbers game. I don't know if you can see there on the screen, but for example, a large CAFO in New York would be 700 mature dairy cows or 500 horses. Very briefly, what's the relevance of all this? Well, under the Federal Clean Water Act, this would be considered a point source. A CAFO is a point source. So if you're working with a CAFO, and I do have clients that run CAFOs, they have to get a permit for the discharge here. So I think that this is a great area of law for livestock lawyers if you're working with animal operations. I wrote a book on New York food and agriculture law that's available on Amazon and Kindle. So for those of you that are in New York and want just a broad stroke of different legal issues that affect New York agriculture producers, I suggest looking at my book. And please stay in touch. I've enjoyed the lecture here today. I have a few other Lawline lectures coming up this summer, and I've done some in the past, so please check those out as well. Thank you.